Alex here with part 129 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my exosperm rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the child custody case, and I am filing an omnibus motion. And that's a motion that's asking the court for multiple different forms of relief. I remember off the top of my head, I was trying to reduce my ex's arrearages to a judgment. I was trying to hold her in contempt of court, and I think I asked for a few behavioral orders. My mindset going into this was, I imagine, negative, because even though I had a lot going on in the other case, the writ case, I had seen two very strong examples of a judge who appeared to be doing everything that he could to get into my way. The first thing that he did was at the hearing emphasize stop filing so many papers over everything else. The second thing he did was deny my motion for judgment on arrearages with no real, at least in my opinion, valid excuse. And this goes into the prejudicial effect of that motion. Luckily, it didn't actually occur, but it could have occurred. Again, guys, I know I said this in the last video, but there's a difference between your ex filing something late or filing something in the wrong way or on the wrong form, and your ex not filing something at all. But all of these things being said, mindset aside, I still filed it. And this is me still following what I have preached in my video, Attack, Attack, Attack. If you have something with merit, file it, even if something else is pending. So I've got multiple things pending right now, and I believe, in fact, I think, yeah, I have the child support issue pending. I have the writ pending, and now I'm filing this motion, so that's going to be pending. Three things that are simultaneously pending, and they are all in different, I guess you could say, areas of the law. I think at this point in time, I know it's a pretty big document, though I think it's mostly exhibit heavy. I don't think that there's a whole lot of points and authorities in it. Let's just go ahead and take a look at what I have filed, because it's going to be, I think, a little bit longer of a video than usual. Here we are with my omnibus motion to reduce arrearages to a judgment. This is the second time I've done this, so I know you guys have seen me go through the arrearages thing before. For an order to show cause, to modify timeshare, for an order to email vacation requests, and for an order restricting certain legal representations with non-parties. Kind of interested in this, guys. I don't really remember this filing, so I mean, a lot of the big ones I remember pretty clearly. Some of them are fuzzy, but I don't remember this one as well. Anyways, let's take a look and see what I filed. Standard introductory paragraph. I identify myself as the petitioner. I indicate to the court that I am appearing in proper person, which means representing myself. I file an omnibus motion to basically what I just stated earlier when I went through the title. And let's go ahead and go into it. The parties in history. This is just a summary as to who's involved. Both myself and my ex, natural mother, natural father, child of age 7 that we share. The next assertion is that the court awarded us physical and legal custody jointly. Now we go into the motion to reduce arrearages to a judgment and for order to show cause. I wonder, guys, I might want to pause here for a second. Thoughts on filing for multiple requests for relief in a single motion? The only thing that I think I would want to do is separate out the order to show cause portion, the portion trying to hold your ex in contempt. The only reason I say that is because that type of motion, it's treated differently. It's not treated as a motion that affects a party's rights connected to the case. Obviously, being fined or jailed affects your rights in other ways, but it's not affecting the rights in accordance with the case that's been filed. It's the Supreme Court of Nevada views those contempt issues differently. They treat them differently on appeal. They don't even treat them. I don't even think they do allow them to be appealed. I think they're only considered on writ petitions. So I think lumping everything together into one motion is probably fine, with the exception of contempt motions. And I'm just saying that's specific to Nevada. And the only reason I'm saying that is because of my experience filing appeals and writ petitions and how the Supreme Court treats those. The only reason I say that is because you might end up in a weird situation where the court disposes some of the issues but not the others. And who knows how the Supreme Court would treat a motion like this that was only partially resolved. It makes me wonder if they would allow it to be appealed while you're waiting, or if they would consider that to be something that's only been partially resolved and dismiss an appeal. It's curious. I really wish sometimes that attorneys were watching that could pipe in on stuff like that. It's very technical stuff. And then the other thing, sometimes your opponent won't respond. It's pretty rare. I think most of the people here on high conflict cases and their opponent responds all the time. But in fact, this happens later too, in my case, where my ex doesn't respond. And the way that the court can treat motions that have not been responded to is also different depending on what the issue is. So for example, a contempt motion, you can't really get a summary order granting. You have to go to a hearing, and the judge will eventually have to get him hauled into court on a bench warrant. But all the other stuff, you can get an order granting just without a hearing at all, much less a response. So I remember later on in the case, I had a couple of things pending, and I actually took advantage of that. And I said, hey, could you resolve this one on the papers, and let's set a hearing on this one, because we have no choice. We have to. I don't know. I'm just trying to say, think about it before you lump everything all together. Maybe do some research and look at how your appellate court treats things that are partially resolved, and also whether or not they even allow appeals from certain issues. Just kind of all the things that I was just thinking of just now as I started going through this document. Aside from that, I guess it's fine. I don't think anything backfired on me with this document. Okay, anyway, number 1. Motion to reduce arrearages to a judgment and for an order to show cause. Again, those are two separate types of relief. I feel like they should have been put into separate sections. Anyway, motion to reduce arrearages to a judgment is me trying to get the court to allow me to seize my ex's assets. And then in order to show cause, you guys know for sure, having seen the last hearing video, it's a way for the court to jail or fine somebody who violates a court's order. July 10th, after chronic and deliberate failure to pay child support, the court entered a judgment and order, reducing my ex's arrearages to a judgment. So this is what I was talking about earlier. I actually already did this once before, back in 2012 of July, and here I am trying to do it again now in 2013. I think, I didn't get the month. Somewhere in July or August, I think, with this document. In any event, next assertion, October 9th, I entered satisfaction of judgment after I successfully levied my ex's bank account and garnished her wages. June 15th, 2013, after numerous requests for an explanation on my ex's non-payment of child support, again, my ex claimed falsely that she had been sending checks to her attorney's office. Like, lying like that, I mean, I don't know. I mean, I guess the attorney will cover for their client, but talk about putting the attorney in the hot seat there. That Exhibit 1, look at that. So I bet I have an email from the lawyer saying they have no checks. Let's remember this when I get to Exhibit 1, guys. Apparently my ex claims that she sent checks to her lawyer's office. And I can't wait to see Exhibit 1. Anyway, September 16, 2013, my ex claimed that she would have child support caught up by the end of the month. She failed to make a payment. September 26, 2013, I emailed my ex and the demand letter. Is this the same statute that I used last time to issue a demand letter, guys? So same exact law, same exact demand letter. It's just going to have different dollar amounts, different dates, stuff like that. USPS confirmed delivery of the letter, and that's Exhibit 4. And then to date, my ex has failed to pay child support. By the way, guys, she doesn't pay this. It just doesn't get paid. It goes all the way to a hearing on the dental neglect. And it's like, she just gets destroyed in that hearing. And this is one of the things that she gets destroyed on. Judge is not happy. And yeah, it's going to be just an insane hearing. I mean, it's just even thinking about it now, like, I don't even know what you guys are going to think when you go through it. Anyway, factual background on medical obligations. Historically, my ex has resisted my repeated requests to coordinate dental appointments. Okay, so this is happening again, apparently. Although I disagree, the court previously declined to intervene on our son's behalf when my ex unilaterally canceled appointments. So I'm using the court's own order denying against him. If you have a judge like this who won't intervene and things get worse, don't be afraid to throw it in the judge's face. It's, I don't feel bad about it. You go to court, you tell them, here's a problem. The court doesn't do anything about it. Things get worse, you go back. and you tell him, not only are things getting worse, but remember those last 2 times when I tried to tell you what was going on and you ignored me? It's after those 2 times you ignored me, we're back now again, and things are way worse. Before he had cavities. And then there was another time when he had, I guess, infected teeth from an ER. Okay, well, now I'm back again, and he has 5 crowns, 2 extractions. Sometimes judges like this need to be embarrassed or shamed, because it's like, it's one thing to say, hey, this is all happening now. Sorry, I didn't tell you before. It's another thing to say, Your Honor, this is what's happening now, and I told you 2 times a couple of years ago, and you didn't do squat. So now things are a whole lot worse, and please do something now. Also, it'll help you a lot if you have to file an appeal, because the appellate court will see that not only did the judge refuse to help you this time, but that he refused to help you the last 2 times. And I should clarify that he refused to help the child the last 2 times. This is something that resonates with the Supreme Court. Not only to see a judge having failed to conduct their duty as, they've been elected to do, but also to see multiple failures or serial failures. In any event, let's continue. March 28th, 2013, I took our son to the emergency room after his daycare provider reported he was in dental pain. This is all old stuff. We've gone over this before. The doctor confirmed that he was suffering pain due to cavities. Okay, next section here. The court commented on the situation. And here's where the judge, I guess, blows some hot air, where he says, this is really bad, and you guys are doing unacceptable stuff, blah, blah, blah. He says all this stuff, but he doesn't do anything. It's called an admonishment, and it's worth almost nothing for a high conflict X. They don't care. This might work on a normal person, but it's not going to work on a high conflict X. In fact, it's gonna actually embolden them, because they're going to say, this is a judge who's not going to actually do anything to me. All he's going to do is yell and not do anything. And since he's not going to actually do anything, I can keep doing what I'm doing. And that's what's happening in this case. He's issued at least 3 admonishments so far. She doesn't care. On June 26, 2013, my ex canceled the dental surgery that she had previously scheduled for our son. July 9th, 2013, I rescheduled the dental surgery with a new dentist. July 12th, 2013, we appeared and consulted with the financial advisor and coordinator to arrange for a payment. My ex agreed to split the costs, and our son had a cleaning. Going into August 2nd, by the way, she reneges on that. Going into August 2nd, 2013, I had a non-party send my ex a medical obligation demand for our son's cleaning. On September 4th, 2013, another non-party sent my ex a medical obligation demand. So here's two demands. On September 16th, 2013, my ex changed her mind, stating that she refused to pay for any of the dental bills on the grounds that she felt the surgery was unnecessary and that our son was not in pain. There it is. Just want to let you guys know, it's not just me saying that she reneged. There's going to be an exhibit for you to read, Exhibit 9. Going into September 20th, 2013, our son's dental surgery was successfully completed. The dentist installed crowns on 5 of his teeth and extracted 2 of his teeth. At age 7, guys, get your head around that. 1 thing per year. So 5 crowns, 2 extractions, age 7. Get your head around that. Another 2 teeth had cavities, but were not repaired due to the fact that they were going to fall out soon. So, okay, let's actually restate that. 9 teeth needed treatment, but because 2 of them were about to fall out anyway, we just let them fall out on their own. My ex failed to appear at the surgery, and I have it in my possession, the extracted molar, so that the court can personally examine the extent of the cavities. September 23rd, 2013, father had, the non-party send my ex a medical obligation demand again for the surgery. She's not going to respond to any of this stuff. She will respond to the court's order when it eventually comes, but none of this stuff matters. September 26, 2013, I mailed my ex the statutory demand letter, Exhibit 3. To date, my ex has failed to pay on any of the medical obligations. So she's not paying the child support. She's not paying the medical obligations. Let's continue on. Argument in support of judgment on arrearages. So guys, I went through this before in my Docket series. It's going to be all of the same statutes, so I'm going to go ahead and skip past this. If you've been watching my Docket series in order, you'll know exactly what I'm doing here. Of course, just with my previous videos, feel free to go down into the description below, click on the links, download this document for yourself, take a look, and if anything there jumps out at you, go ahead and post it down in the comments below and I'll answer your question to the best of my ability. But the reducing of judgment to arrearages that I'm doing now is the exact same thing that I've done before, so there's going to be nothing new to go through there. I think it's just more money that she owes. Argument in support of order to show cause. Pursuant to the law, disobedience, or resistance to any lawful writ, blah, blah, blah. I've tried to hold my ex in contempt of court at least 2 times, maybe even 3 times before. None of these laws are different, guys. Same exact law, same exact affidavit, the Awad v. Wright affidavit. Nothing is different. So as I mentioned before, I'm just going to move straight through this portion. It's probably even copy-pasted. Motion to modify timeshare schedule. And here I am using the best interest of the child to request a modification of timeshare. Upon entering first grade, it's become more important than ever that our son establish a reasonable and consistent bedtime. Week on, week off timeshares was previously suggested by the court. Hearing at that order to show cause hearing on the basis that it would reduce contact between the parties, and accordingly, I am asking for a week on, week off schedule. Motion for order to email vacation requests. Existing orders require that parties notify each other of vacation claims by certified mail. My ex has claimed to have sent a vacation request this year, but refuses to provide a copy of it or the tracking number. This is because she's lying. If my ex had proof, she would have provided it. Rather than bring this petty dispute to court on a contempt motion, I am asking the court to provide a copy of any future vacation requests via email. Guys, I have to agree. The certified mail thing is silly. Somebody can claim they mailed something and you just didn't get it. It's nonsense. From the beginning, we should have been doing this through email. I don't even know why my ex's attorney thought that this was a good idea. Like, why did it dawn on her to do it this way? It's almost like she's facilitating the high conflict. I mean, unless she advised my ex to go with emails and my ex said, no, I don't want to do that. Maybe then she was just kind of representing her client. But I have a suspicion here that this attorney knew better than to order something like this or ask something like this to be ordered. And as predicted, I mean, I'm sure I predicted this back then. As predicted, here we are back in court with my ex claiming she sent a vacation request that she never sent. Next section. Motion for an order to restrict legal communications with non-parties. Okay, so let's see what's going on. As one of the preconditions of our son's dental surgery, Dr. Jason McKenzie needed to clear him for general anesthesia. I notified my ex of this critical requirement and asked her to schedule the appointment, or in the alternative, notify him that she would be unable to do so. On September 12th, after hearing nothing from my ex, I scheduled the appointment with his general family physician, I think they call it, and notified my ex of the appointment. Because it was on such short notice, and because I did not want to delay the dental surgery any further, and there were no other available dates, I was forced to schedule it on her day. Next section. On September 16th, the same day of the appointment, my ex notified me that she would not be taking him to the appointment. I appeared at the school with the intention of taking him, and I was unexpectedly interrupted by my ex, who approached the front desk, notified personnel that she would not be taking our son to the doctor's appointment, and that if they allowed me to do so, she would hold the school in contempt of court. Now I remember this. Yeah. So guys, just read it just read it again. She's not a neglectful parent in the sense that she doesn't care and she's not involved. It's the opposite. She actively takes steps to get in the way and prevent these things from occurring. She literally, not only did she refuse to take him to get his appointment, she literally showed up at the school and threatened the staff that if I took him to get the appointment, she would go after them in court. This is the kind of stuff that insane high conflict people do. It's like, sometimes I look at people who claim they have exes that are neglectful, and I'm like, I wish I had one of those who just wasn't involved so I could just do everything. But instead I had one that was involved, but that had these really twisted, warped motives and took not passive steps to harm him, but active steps. Like, took time out of her day, left her job, went all the way to the school just to not take him and tell them that I wasn't allowed to. Like, get your head around that, guys. It's not like I was trying to take him home on a visit that I wasn't supposed to have, which, by the way, that's still a silly thing to go to the school for and cause a scene. It's me saying, hey, I'm going to take him to this doctor, get this treatment done, and drop him back off. Like, you guys are going to hear all about this at the hearing. It's going to go into the testimony. Sorry, it's going to go into the record through testimony. Anyway, let's continue. Although my ex's attempt to derail the surgery eventually failed, and I know why this happened, it is possible that issues like this can arrive in the future, and I'm basically asking the court to not allow either of us to discuss these legal, to discuss our child custody case with these third-party members in the sense that we're going to threaten to do something against them in our case. You could always threaten to sue someone in a separate case, but they're not parties to this case. So how is she going to hold them in contempt? There's none of the orders of the court are binding on them. I guess that's what I'm trying to say. These orders are binding on us. So, by the way, I mentioned that it eventually failed. The reason why is because I called the doctor and I told him what my ex was doing. And he said, you know what, when do you pick him up next? And I told him when, and he said, just come on in as soon as you pick him up. So my ex succeeded in blocking me from taking him, but as soon as my ordinary pickup time came, I just picked him up and took him to the doctor's office. Really cool doctor for him to do something like that on basically no notice at all. Mediation. Local rule, I've talked about this before. It's my boilerplate get out of mediation free card. Love using this. You've heard me talk about it before. Definitely take a look at your court rules to see if you have a similar rule that allows you to get out of this. Conclusion, and this is just me asking for everything that I discussed in this document. I'm asking to reduce $2,242.13 to a judgment. I'm asking for interest and penalties at 15.25% per annum. I'm asking for an award of costs. I'm asking that my ex order to show cause while she not be imprisoned. I'm asking for a modification of timeshare to week on, week off schedule. I'm asking for the court to order us to send vacation requests through email. And then I'm asking the court to order that non-parties are not subject to this court's orders in this matter. Next, we have the verification and declaration in support of contempt. This is the same declaration that you guys have seen in support of these documents in the past. It's just me swearing under penalty of perjury that the facts alleged in this document are true and correct. I also want to mention one more thing, guys. In Nevada, the Awad v. Wright affidavit has to be more specific. You can't just use like a generic paragraph like this. This came up, I don't remember now when. It's not that old of case law. For a long time, they allowed this. This was fine. But I know that they changed it, and they considered this to be not good enough, and they want specific detailed allegations in the Awad v. Wright affidavit if you want to hold someone in contempt. Next, we have a certificate of NRCP 5 service, me indicating that I served this document upon my ex's attorney, more likely her a staff member that worked in her office. Here we have the motion opposition notice. This time, based on the check marks, I did have to pay a filing fee, and it would have been a filing fee of $25. We have the list of exhibits. 2 emails, a demand letter, delivery confirmation, more emails, dental cleaning, dental surgery. These are letters, tons and tons of emails and letters. It looks like all these documents I'm going to be going over. None of these look like duplicates. Exhibit 1. All right, so let's start from the bottom. Okay. I'm saying that I'm trying to get a heads up on child support. Is it being paid this month? My ex responds that she is totally confused about child support. She says when she's tried to pay me that I wouldn't cash her check. What? When did this happen? Totally confused, and Kathy said I filed to redo child support? This is bogus. Which is good because I am paying more for insurance and making less money at work? What is she talking about? This is crazy. Okay, so yeah, no clue what hearing I am talking about. This is her just playing dumb. Next document we have, I think the normal time is Monday. I've been mailing, if you've been mailing anything to me at my new address, and then here's the address, I would appreciate info on the vacation claims. I haven't heard anything about the dentist. Let's go to the next one. You know what? The court order says you should have brought him back at last night. Then she would have dropped him off at 3 and picked him up at midnight 30. I didn't bring him back, so I'm in contempt, she's saying. Okay, well, that's news to me because she doesn't file anything. She'll notify her lawyer, and if I don't bring him back by midnight 30, then she'll ask her to add this as well. She's been trying to work with me and let me keep him overnight so I wouldn't have to bring him back. But since I didn't bring him back like I'm supposed to, I don't know what this is, guys, but this doesn't turn into anything. This never gets filed. So maybe if she filed an actual motion, I would remember what this is about, but I don't remember what this is about. Next document is, this is the way we've been interpreting vacation days that connect to the actual days ever since the, I know what this is now. This is when she tried to change the interpretation of the court's order on vacation or holiday days and or both. Guys, I already talked about this in that, I think it was in the hearing video that I talked about it. Anyways, I know that I talked about this before, and I know that the solution to this kind of crazy response from your ex is to look into the video interpreting court orders. The courts will, at least in Nevada, they will look to the way that you and your ex have been interpreting a court order to determine whether or not you're in contempt of court. So she can't just decide, I'm going to change the way this order is interpreted halfway through, I don't know, all the years that we've been interpreting it that way. It doesn't work like that. And that's probably why her lawyer never files anything. Her lawyer probably had to sit down with her and told her that there was nothing she could do. And then she says, am I dropping him off tonight or not? Which is the end of the thread. Exhibit 2. Let's start from the bottom again. Okay, that's the only one. Exhibit 2, I just paid the dental portion of $1366.90. A reimbursement request will be coming in the mail shortly. They're scheduling the surgery. We have the anesthesiologist and hospital portions coming up. I'm curious as to child support. Still waiting. Her response, I'll try to have child support paid to you. Exhibit 3. Letter. So this is my demand letter consistent with NRS 125B.140 subsection 2A. You guys have seen one of these before. This is what I start, this is what I use to start the process on reducing the child support and medical obligation arrearages to a judgment. Yeah, this is not just child support this time. There's 2 things here. Anyway, confusing me. Sorry about that, guys. Here is the ledger. You can take a look. Exhibit 4. Here is a certified mail. This is required by statute, by the way. I didn't do this as an above and beyond or as an extra. The law specifically says that you have to do this, at least in Nevada and at least for this specific procedure. Exhibit 5. Here we have, let's start from the bottom. Picking our son up, got a call from the dentist. The surgery stuff is next week, Wednesday. Dentist wants to meet him. They booked a last minute appointment. Next is my ex. Wait, hold on. So that one was from my ex. Okay, this one's also from my ex. So after talking to the surgery center, the anesthesiologist, and her insurance, the dental won't cover the surgical center, and her medical doesn't think it's medically necessary, so they won't cover it either. This is ridiculous. I remember this comes up in court and she gets destroyed on this issue too. The surgery center, and so she goes through the dollar amounts. They want us to pay up front. She doesn't have this much money. So guys, guess what I did? I could have argued with her. No, I just paid it. I paid it and then I went after her later. Next we have, I want to make sure that it's clear that this response is not to fight with you or make you look bad. This is my general observation of the situation. It looks to me like they were annoyed that you violated procedure when you approach the operating area. I know Army is in pain and you want to be there to hold his hand, but if you get in the way, and see, so here I am trying to explain to my ex what she's doing like she doesn't get it. And she does. So this shows that I still don't fully understand what's going on with my ex. This is me thinking that what she's saying she actually feels, which is one of the things that I try and get my viewers to stop doing. When you're dealing with a high conflict ex, they're playing dumb. They know what they're doing. You might think you need to explain it to them because they don't get it, but they do. They know exactly what they're doing and they're doing it anyway. They're doing it on purpose. So I'm trying to explain to her my perspective and my observations. And by the way, I could have sworn I remember her responding to this argumentatively, but I don't have it attached to this thread. Next document. Let's start from the bottom here, I guess. Let's see. I scheduled an appointment with Dr. Molina. I'm going to give your intermediate a call since I don't have your number. Her response, required to give the address and phone number. My response, per Google, and then I give her the address per Google. And then they said you're in network. So yeah. Next document is medical debt. Who sent this? Okay, so I did in accordance with the court's 3030. Okay, so this is my request consistent with the 3030 provision to trigger a repayment by my ex. And guys, if you want to know more about this, please watch my video on 3030 rule. That's what it's called. Exhibit 8. Here we have another demand. Yeah, this is a demand, $13.66 and 90 cents. In accordance with the court's 3030 provision, same thing, guys, another demand for money reimbursement. And again, watch the 3030 rule. It's a great video. Payment. This is my proof of payment, $13.66.90. Exhibit 9. Don't threaten me. Okay, wait, let's start from the bottom. Where's the bottom? Okay. You haven't responded regarding Army's pre-op, so I scheduled it myself. He needs to go to Dr. McKenzie on Monday. Surgery is on the 20th. I'll put a packet of the surgery dental stuff in his backpack. Okay, next section. Next section. Wow, this is a big one. My ex and I have something important at his school tomorrow. What is the important thing? Anyway, I can't schedule things on her days. So this is, again, she's just trying to find a plausible explanation as to why she's trying to frustrate the needs of the child. She's trying to say, it's my day and you can't schedule it. Can't pick him up when she has custody. If I choose to take him to the doctor on one of my days, give her notice, it's fine. If I think I can handle filling out paperwork and dealing with medical stuff, fine, but then I need to take responsibility for it. What she's trying to say is that I need to pay it all. This is one of the things that she uses later. She doesn't agree to the surgery. She doesn't agree to the anesthesia. And since her insurance won't pay for it, she's not required to pay for it. So this is not true. The judge is going to just nail her to the wall on this. I think she cries harder this time than last time. Let's put it that way. Next section here is, if you decide to go ahead with it anyway, then you need to let me know the time to show up. So she doesn't show up. I do let her know, but she doesn't show up. The only thing that you have said in the email is that it's occurring on the 20th. I have nothing. She's received nothing from anyone in the mail. And when she went to handle the tonsil surgery, she made the appointments on her days. So this is her trying to say that since she did this on her time, then I need to do it on my time. Again, this is not really relevant to what's going on. Next section is that I'm not prepared for the surgery. And if I think that it'll just be one day, then I have to think again. He's going to need round-the-clock care for several days. This isn't true. In fact, the dentist will testify on the stand to specifically this statement. So this is another thing she gets dinged on in court. Next section is my ex will be able to take a vacation in January. Army will need 10 vacation days from school to recover in. So hopefully he won't miss any days. Okay, next section is that it is better to do it January. She's saying if I do it now, then it's all on me financially and for the responsibility. So even though your ex says this, if you do this now, it's all on you. It's not really how it works. They can say what they want, but what's going to happen is they're going to get trampled under the law. The law doesn't really care what your ex says. The law will just flatten him and move on past. I mean, that's what's going to happen. She's going to say all of this in court, and then the judge is going to say, you are hereby ordered. And then she's ordered now. So anyway, next section. He's starting well in school. She knows from personal experience after having dental work, sometimes the pain is significant. So this is kind of like a lecture where she's trying to act knowledgeable. But she's so knowledgeable that she doesn't want him to get treated. In fact, the judge mentions this specifically. She looks at my ex in the eye and she says, you, as somebody who works in the medical profession, should know better. That's one of the things that the judge tells her. You'll see. And let's go into the next section. Exhibit 10. Proposed treatment plan. So this is what the dentist provided, guys. It's not really a legal document, so I'm going to just let you take a look at it if you want to. But this is all the stuff our son needed from the dental damage that he suffered. Exhibit 11. What do we have here? So this is me, I guess, hitting her with a 30/30 provision on 1194 and 1121.25. So 2 more 30/30 hits. This is all going to get added up into a massive amount of dollars. Next section is Exhibit 12. So let's start from the bottom. This is the bottom right here. Yeah, this is it. My ex says in the future... Wait, I'm telling my ex, in the future, when a court order is violated, you don't have to freak out or be stressed. I'm not trying to get you. It's not my thing. If you forget to send a homework packet, just relax. Try to find another way. Okay, so this is me extending an olive branch to my ex after getting her held in contempt of court. Guess what she says in response? I remember this one. She says, stop harassing me. In any event, this comes up in court too. And the court tells her, after reading that specific email, she says, you don't get to take his olive branch and beat him over the head with it. It's a line I never forgot. Here's me proposing week on, week off schedule. These diagrams are pretty cool, guys. I guess, they might help some judges. I don't know if it's a huge deal with like a week on, week off thing, but for complicated schedules, it might help. Exhibit 14. We have to schedule surgery appointment with Dr. McKenzie within the next few days. And this is what I was talking about earlier, where it was urgent to set that appointment with the family doctor. Exhibit 15. Let's go to the bottom. Whoa, this is a big one. I think I already went through this. Haven't responded regarding the pre-op, so I scheduled it myself. Yeah, I went through this. Is this a duplicate? Yeah, this looks like a duplicate. Okay, so maybe this is my response to her. I'm saying here that I would rather do it January, but his teeth have massive issues. So this is me saying I don't want to delay the procedure. I would never ordinarily schedule something on your day. Me trying to explain myself when she already knows. The court order says any medical issues that are incurred that are out of network are my responsibility. But this isn't fully true. It's only if there was a in-network option available. If there is no in-network option, then you both split the costs. Curious if you would be at the procedure for time economy purposes, and it would have gotten you a packet if you would have told me in time. That's why I sent the previous email asking to let me know before Saturday if that's what you wanted. Okay, etc., etc. Next section. Okay, next section. Exhibit 16. Schedule of arrearages. This is a form I probably got from the website, from the court's website. And that's it. Going into the aftermath, I filed one document. It was not a free filing, so I had to pay $25 in costs. My ex filed no documents, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney might have, for sure, she spent time looking this over because she's going to have to file an opposition. But even though it's a huge document, not much of it requires legal research. There are a lot of emails to go through. I do think it's going to take her quite a bit of time to go through all of those, but I'm going to put more of that time into the opposition that she will inevitably file. Right now, for just reviewing my motion, I think 30 minutes is pretty reasonable. It's a lengthy document. There's a lot to look at. There's something to bring up to my ex's attention for her to communicate with my ex. So again, guys, when she files her opposition, I'm going to take more of this into consideration. But for now, I think 30 minutes, half an hour for my ex and attorney fees, which at the rate of $250 an hour comes to $125 in attorney fees for my ex. As with my previous videos, feel free to post any questions or comments you have down in the comments below, and I will see you guys next time.